If you're going through a child custody case and you have kids who are a little bit older or kids who are able to express themselves maturely, those kids may be expressing opinions about what they want custody or parenting time to look like. And if you're in that situation, you may be wondering, well, is there a certain way that I should get my kids' wishes known to the court? And the answer is yes. There are certain ways that you should get those wishes known to the court and certain ways that you definitely should not. In today's video, I'm going to talk about the ways that you do not make your child's wishes known to the judge. So hang on for that information in this video. If you're not already a Command the Courtroom subscriber, go ahead and hit the notification bell below. By hitting that notification bell, not only will you become a subscriber, but you're going to get notified each time Command the Courtroom releases a new video. Also, if you like this video, don't forget to give it a thumbs up. My name is Wendy Hernandez, and I'm a Phoenix family law attorney. I've been practicing family law in Arizona since 1999. I'm also the creator of Command the Courtroom, and I am passionate about helping people just like you get ready to present your case in the family law courtroom. The last thing I want to see is a person feeling overwhelmed and lost and paralyzed by fear. I want to empower you with the tools and the information you need to go into the court and give it your best go. All right, so let's dive into today's topic. What are the things that you should not be doing if you want your child's wishes to be known to the court? So, first thing, I want to give you a little bit of brief background. As you may or may not know, and you should know if you don't know, so watch more videos, especially on the best interest factors. But if you don't know, a court is going to be looking at what is in the best interest of the child in your case, what is in the best interest of your children. And wherever you are, there is a list of factors the court must consider in making a decision about your child's life. Those are called the best interest factors. So one of those factors is of what are the child's wishes? If the child can express him or herself, what are the child's wishes? Now, people often wonder, do kids go into court and do they testify and tell the court what their wishes are? Well, the answer is in my jurisdiction, the kids do not do that. They do not go into court. They're not put on the stand and they don't testify about what they do and they do not want. So sometimes it becomes a bit of a challenge getting the child's wishes known to the court. I see parents make lots of mistakes in trying to get those wishes known. And I'm going to outline those here for you so you don't make those same mistakes and risk getting the judge really upset with you and it affecting your case. So, mistake number one, parents interview their children about what their wishes are. So, I'm hoping that at this point, somebody's told you never, never, never get your child involved in your litigation. It's so unhealthy for the child. In most cases, children love both their parents. They want the approval of both their parents. They want to make both parents happy. But by putting the child in the middle, it really leads to some cognitive dissonance for the child and could lead to some trauma too. Do not ever put your child in the middle of your court litigation. And one way that you are going to put your child in the middle of that litigation is by interviewing the child or children about what it is that they want and then telling the court, well, I talked to the kids, I asked the kids questions and this is what they told me. Judges are not happy when parties get involved with their kids' wishes and then reporting those wishes to the court. Now, it's one thing if a child kind of spontaneously tells you, like, I like living with you more, Dad, because XYZ, or I like living with you on these days, Mom, because of XYZ. But it's an entirely different matter to go and interview the kids and report those findings to the court. If you want to testify about what a child told you spontaneously out of nowhere, then you need to give the court some context. Otherwise, the court could take it the wrong way. But again, by interviewing, you're putting the kids in a really rough spot, a potentially trauma-inducing situation, and you're forcing them maybe to take sides, something that they don't want to do. So never interview your children, then report those findings to the court. Mistake number two that I see people make is recording their children And then not necessarily directly interviewing them, but kind of leading the children to say things that may be harmful to the other side's case, and then presenting those recordings in court. My clients in the past have presented me with these recordings, and I've listened to them and I think, okay, the kid is saying XYZ, but it kind of feels like they're being tricked into saying XYZ. And plus, they're being recorded when the parent should be parenting the children. And I have always been reluctant to admit these types of recordings in court. I feel like they are not helpful to my client or to the case. A judge understands that a parent is motivated to do certain things to get what they want. And I don't think that the courts give these types of recordings tons of weight. So I discourage you from recording your children and then presenting those recordings to the court. There are certain ways of, quote, recording the children, which I'll talk about one in just a minute, but that is not the way you do it. Do not record your children. If you're going through a child custody or parenting time case, I want you to tell me in the comments below whether your children's wishes is one of the factors that you think applies in your situation. And if you think it's one of the best interest factors that applies, tell me why. And tell me a little bit about your kids and why you think they're of sufficient maturity that their wishes should be communicated to your judge so the judge can consider those things in making an ultimate decision. All right, so let's get back to one of the other mistakes that I frequently see people make and that I recommend you do not make. If you have children who are old enough to express their wishes to the court, do not, under any circumstance, have your children write a letter to the court about what it is that they want. Of course, unless the court has said, I want the kids to write a letter. So many, many, many years ago, I was involved in a court case where one of the parties told all of the kids, write letters to the judge, tell the judge what you want, tell the judge why you want it. And the judge in that case was livid. And the judge punished the offending parent. The judge gave a really punitive parenting plan to that parent. And I think not only was it punitive to the parent, but it was punitive to the kids. It was very sad. And the party that told the kids to write the letters could never recover. So please don't make that mistake. And this, telling the kids to write a letter, unless you're ordered to tell the kids to do that, or unless the court tells the kids to do that, that is, again, putting the kids in the middle of the litigation. Putting the kids in the middle of litigation is one of the cardinal sins of custody cases. You do not want to put the kids in the middle. It is harmful to them. Okay, so the recap is, number one, don't interview your children and then report those interview results to the court. Number two is don't record your kids, either secretly or not secretly, and try to lead them into answers that would support your case. Then try to present those recordings to the court. Judges are usually not happy about that. And then number three, don't ask your kids to write letters to the court that you try to submit later into evidence. Now, I do have videos on how kids' wishes are communicated to the court. So check out those videos on the Command the Courtroom YouTube channel. But I will tell you that many courts have tools and mechanisms in place where a kid or a children appointed by the court, and then that professional presents the results of the interview to the judge. And the professional interviews the children in a way that is non-threatening, not putting the kid into the middle, considering the child's feelings and thoughts and the fact that the child might be feeling like they have to take sides. The professional is trained to deal with this, and then they will objectively report those results to the court. There are some judges in some jurisdictions where the judge actually interviews the children themselves. And hopefully the judges have training when they do this, but that doesn't exist in some places. So again, check out some of the other Command the Courtroom videos on the topic. And if you haven't already, I highly recommend that you download the Command the Courtroom Best Interest Checklist. I was talking about those best interest factors earlier, and the wishes of the child is one of them. Well, there is a whole laundry list of best interest factors, and I compiled that list several years ago. So this best interest checklist is going to help you figure out what you need to present to the court so you make sure that the judge has all the information he or she needs to make a decision that serves the highest good of your family. So check out all the other Command the Courtroom videos. Again, if you haven't already subscribed, hit the notification bell below, give it a thumbs up. And until next time, remember to keep on trucking and get out there and command the courtroom.